Varnani Anyani Samyati Navanu Dehi. He is coming to you with facts and figures, with rarity and reality, with annotations and authenticity, for your audacity and addiction, for your joy and peace, for your benefit and welfare, for your day and the dream, for your drift and draft. No matter how good and how bad you have it, someone, somewhere, and something is desperately feasting your body, mind and the soul towards destruction. From birth to death.
It is also for everybody. Yes, because we are interested in the institution. Either myself, my brother, or the VP, or Mr. Rajagopal, or the other advocates, and Mr. Pankanagara, and Mr. India Prasad. Everybody is interested in the institution.
May I make a mention that in the contempt proceedings, the charges were so far not framed in blood. Before ever Mulad framed our charges, the parties are Mulad inquired. That is the legal charges to be framed, then Mulad.
Now I will pass the order. Please, 1 minute, yes. The last paragraph. We have no fear or hesitation in dealing with the matter and punish the contempt not properly according to law. However, on the facts and circumstances, we are of the view that taking action only against Mr. P. Dharmaraj and Mr. A.K. Ramasamy, the contempt of herein would not be sufficient to provide to persist illegal activities, which is going a number of years after the constitution of Madurai bench. A suggestion was placed before us by persons interested in the institution to consider concurrent filing of cases at the principal bench or closure of the Madurai bench for a certain period. Similarly, directions to the High Court administration to prevent illegal activities of certain group of lawyers. Similarly, to decide security arrangement to be made by the central uniformed force. We find it reasonable that laundry bench has to be consulted, preferably headed by the Chief Justice, to give a full stop to the illegal activities of certain lawyers acting against the judicial institution, one of the important pillars of democracy, and also against majority of the advocates interested in the profession. But this is directed to place this matter before the Honorable Chief Justice for passing appropriate orders. We feel, I myself feel, that it should be placed before a larger bench to give a quiet test. Because today Mr. Dharmaraj is available, Mr. A.K. Ramasamy is available. Tomorrow some other Kupusam and Bakrisam may be available. But we have no great against this person or any other person. But the institution should function properly. Therefore we need a proper guidelines from the Chief Justice. Yes, for this we need a lot.
This is a mindless litigation, and it's not a stray case. This kind of litigation goes on in this country every day in many courts. But I don't understand. I can multiply the examples. If only I'm given time, in the next 10 minutes I can tell you 10 examples which I dealt personally. It requires a clear policy on the part of the state. When I'm talking, private litigants need not have a policy because they are individuals. They have no obligation to the rest of the society, barring moral obligations or legal obligations stipulated by the law. But in the matter of litigation, they don't know any obligation.
I find that a vast number of the cases are unnecessarily entertained in the name of public interest. I only wanted to remind ourselves that people who make law also are aware of the public interest. They are also conscious of the public morality. They are also in the knowledge of the constitutional morality.
To me, a judge who hears a case must deliver a judgment preferably within a month, and in any case within 3 months, as has been cautioned by Justice Thomas in the judgment. Not more than 3 months. Then what happens if a judge does not deliver a judgment in 3 months? I would tell the Chief Justice, whether it is Chief Justice of India or Chief Justice of the High Court concerned, should not allocate work to a judge who has judgments pending for more than 3 months.